Good afternoon, good evening, bon après-midi, bonsoir. My name is Una Fitzgerald. I am the president of the International Law Association of Canada. Welcome to this latest ILA Canada webinar, New Frontiers in International Commercial and Investor-State Arbitration. Definitely not your father's Oldsmobile. Bienvenue à ce webinaire de l'ADI Canada, les nouvelles frontières de l'arbitrage commercial international et entre investisseurs et États. Certainement pas la Oldsmobile de votre père. L'Association de droit international a été fondée à Bruxelles en 1873, il y a 150 ans. Et maintenant, il est basé à Londres, au Royaume-Uni, avec plus de 4500 membres dans le monde entier. According to the ILA's constitution, we promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. Une grande partie de ce travail se fait par l'intermédiaire de comités qui étudient des sujets de droit international et de conférences biennales. Membership to ILA Canada is open to the whole Canadian international law community, academics, practitioners, policymakers, and students. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, it is customary to acknowledge the traditional territories and ancestral lands of Indigenous peoples. We are meeting virtually, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and the inherent protectors of the lands and waters where each of us attends this meeting today. We are grateful to live on, learn from, and enjoy this land, and commit ourselves to decolonization in our personal lives, our businesses, organizations, schools, and in our communities. Les engagements que nous prenons dans cette reconnaissance de terre doivent être activement poursuivis à s'accompagne de la conviction que la décolonisation commence par la réconciliation avec tous les peuples autochtones, y compris les Premières Nations, les Inuits et les Métis. Pour que la réconciliation soit couronnée de succès, nous devons continuer d'approfondir les façons dont nous écoutons les peuples autochtones en tirant des leçons et les soutenant, ainsi que leur résilience, leur résistance et leur autodétermination. C'est avec grand plaisir que je vous présente deux de mes estimés collègues qui ont organisé ce webinaire. Le professeur Charles-Emmanuel Côté et l'honorable Barry Leon, qui serviront tous deux de modérateurs pour ce panel. Charles Emmanuel Côté is full professor at the Faculty of Law of Université Laval in Quebec City and member of the École supérieure d'études internationales, where he teaches public international law, international economic law, and constitutional law. He's a member of the board of directors of the International Law Association of Canada, the Canadian Council of International Law, and vice president of the Société Québécoise de Droit International. He is a member of the ILA Committee on the Rule of Law and International Investment Law, and a member of the Investor-State Dispute Settlement Academic Forum, collaborating with the United Nations Commission on International Trade Law, UNCITRAL, on ISDS reform. Professor Côté is a member of NAFTA Chapter 19 and CUSMA Chapter 10 panel roster for Canada. The Honorable Barry Leon is an independent arbitrator and mediator specializing in commercial disputes. He was presiding judge, British Virgin Islands Commercial Court. He is a Chartered Institute of Arbitrators Fellow, International Mediation Institute Certified Mediator, and International Academy of Trial Lawyers Fellow. In addition to a law degree, he has an MBA. Barry's accolades include an award for distinguished service in Canadian arbitration, Chartered Institute of Arbitrators, Canadian branch, and Global Arbitration Review Best Prepared Arbitrator Award shortlist. Barry is a long-standing director of ILA Canada. His many other professional involvements include chair or co-chair of ICC Canada Arbitration, CIARB Caribbean Branch, ITA's Caribbean Task Force, and Canadian Arbitration Report. He is co-executive editor of the Canadian Journal of Commercial Arbitration and a co-moderator of OJMID. I now turn to Barry to introduce the topic of today's discussion. Thank you.
Thank you, Anna. Charles and I take pleasure in welcoming you to New Frontiers in International Arbitration. Definitely not your father's Oldsmobile. Our objective for this webinar has been to bring together Canadian experts on international commercial arbitration and investor-state arbitration to discuss similar evolutions and developments in and common challenges facing both regimes. We've certainly been successful in bringing together the experts, as you will hear Charles introduce them shortly, if you're not familiar with them already. We want to focus in the next 2 hours on current and likely developments that affect or may affect both forms of arbitration, and developments in one that are likely to impact the other. We believe that it will be interesting to have a combined look at both forms of arbitration, since they often are examined separately. Despite divergences that have been developing, there are many lessons that we think can be learned for each by discussing both together. Charles Emmanuel and I will co-moderate the discussion. We have 5 main topics. They are independence and impartiality, diversity, transparency, types of parties, inequality of arms, and then we will have some other secondary topics if time permits. There will be a lead speaker on each topic, followed by comments from one or more of the other panelists. There may be time after each topic for questions from the audience, so if you do have any questions, please put them in the Q&A function, and we will keep an eye on them. Those will be questions relating to the particular topic. And then at the end, we will again have time for, hopefully, for questions more generally. After we discuss the 5 topics, our rapporteur will pull together in her remarks in about 10-12 minutes the discussion and key points coming out of it. And after that, we will have the Q&A. We will also, towards the end of the discussion, call on each of the panelists to do a little crystal ball gazing and to provide some key insights on where they think all of this is going. So on that note, let me turn it over to Charles Emmanuel, who will, I think, repeat what I've said in French and introduce the speakers.
Thank you, Barry. I will indeed say a few words in French, but try not to repeat what you've already said. This event will be conducted mostly in English for the sake of for the ease of the conversation between the speaker. However, vous êtes les bienvenus pour poser les questions en français dans la fonctionnalité questions et réponses, et il nous fera un plaisir de poser les questions en français ou de les traduire en anglais pour nos conférenciers d'aujourd'hui. Quelques petits mots en français pour compléter la présentation du sujet faite par Barry. Il nous est apparu qu'il y avait deux perspectives souvent à partir desquelles on examinait l'arbitrage international. Il y en a une, et ce n'est pas dans un ordre de préférence, il y en a une qui est plutôt celle du publiciste qui appréhende ce phénomène à partir du droit international public ou du droit public. Ce regard est peut-être plus familier avec le règlement des différends entre investisseurs et États, l'arbitrage investisseur-État. Il va voir plutôt l'aspect du contentieux de responsabilité de l'État pour violation d'une obligation internationale conventionnelle. Et ça va être à partir de cette grille qu'il va examiner le phénomène de l'arbitrage international. Je vous confierai que c'est la grille, c'est le regard à partir duquel j'observe ces développements. Mais il y a aussi un autre regard, qui est le regard plutôt du privatiste, qui va examiner l'arbitrage dans la perspective plutôt du droit international privé, qui va souvent être plus familier avec le contrat commercial international, avec l'arbitrage conventionnel fondé sur un contrat commercial. Et ces deux regards-là sont tout à fait pertinents et c'est un peu ce qu'on a voulu amener dans cet événement d'aujourd'hui. Je ne peux pas m'empêcher de faire référence à une autre métaphore que celle de la Oldsmobile, qui, pour une oreille francophone, fait écho un peu plus lointain à une publicité américaine qui est moins connue en français. Par contre, le professeur Alain Pruginaire a publié un article dans la revue de l'arbitrage en 2005 où il utilisait une autre métaphore qui était celle du coucou, cet oiseau qui fait son nid et qui pond ses œufs en fait dans le nid d'autres oiseaux. Et c'était la métaphore qu'il avait utilisée pour décrire le phénomène naissant de l'arbitrage investisseur-État qui a pondu ses œufs dans le nid de l'arbitrage commercial international. Et son article est tout à fait toujours pertinent. Il posait la question de savoir est-ce que c'est une chose positive ou négative. Et il en venait à la conclusion, pour lui, en 2005, qu'il était peut-être préférable de séparer les deux régimes d'arbitrage plutôt que de les mélanger ensemble. Et donc, c'est une question que nous allons un peu examiner à travers nos discussions aujourd'hui. Et c'était donc l'idée que nous avions de faire ce regard croisé sur la convergence et la divergence entre l'arbitrage commercial international et l'arbitrage investisseur-État. Nous ne sommes pas originaux, nous ne sommes pas les seuls. Je ne saurais passer sous silence la publication récente d'un ouvrage magistral en 3 volumes co-dirigé par Andrea Björklund, qui est le Cambridge Compendium of International Commercial and Investment Arbitration, qui prend exactement cet angle pour étudier l'arbitrage international. Donc, nous allons avoir la chance de bénéficier de ces commentaires lors de nos discussions et spécialement lors de son rapport de synthèse. La question qui se pose est sans doute de savoir est-ce qu'il y a une contamination de l'un régime d'arbitrage vers l'autre ou un enrichissement, ou les deux peut-être. C'est une des questions que nous allons examiner. Alors, I will briefly now present our panelists that most of you already know probably, so I will refer you to the written biographies that you may find on the website of ILA. In the alphabetical order, we have Louise Barrington that will be one of our panelists. Louise Barrington has been teaching and arbitrating international commercial disputes for over 25 years in Hong Kong, Europe, and North America. She founded and directs the Vis East Moot, which was the first virtual competition and the precursors to many virtual hearings. Louise has founded Arbitral Women, dedicated to supporting and promoting women in dispute resolution. We also have Andrea Björklund, who is a full professor and Yves Fortier Chair in International Arbitration and International Commercial Law at McGill University, Faculty of Law. Andrea is an arbitrator and an expert in both investment and commercial arbitration. Before entering the academy, she was an attorney advisor on the NAFTA arbitration team in the Office of the Legal Advisor of the US State Department. Matthew Crombie is our other speaker and panelist. He's a partner in the Competition and International Trade and Foreign Investment Group at Osler in the Toronto office of Osler. He was previously Director General of the Government of Canada's Trade Law Bureau and was Canada's Chief Legal Counsel in the negotiation of the CETA with the European Union and various other trade and investment treaty negotiations. Matthew teaches international trade and investment arbitration at the University of Toronto Faculty of Law. Laurence Marquis is an assistant professor at the University of Sherbrooke Faculty of Law. She specializes in dispute prevention and resolution. Her research focuses on national and international dispute prevention and resolution, international commercial arbitration, and ISDS reform. She has over 15 years of experience in various settings in arbitration. She notably worked at Jones Day, at the ICC in Paris, and at the Trade Law Bureau in Ottawa before becoming a professor of law. We have, finally, not the least, Janet Walker, who is an independent arbitrator with chambers in Toronto, London, and Sydney. She has served as sole arbitrator, co-arbitrator, and chair in both ad hoc and institutional arbitrations in a variety of seats. She's a distinguished research professor and past associate dean at Osgoode Law School, where she teaches private international law and international arbitration. She authors Canada's main text on conflict of laws, cited in more than 400 judgments. Without any more words of introduction, I would, Barry, let you introduce our first topic for this panel.
Yeah, you just might want to add, unless you didn't, I missed it. Martin Doe was to be with us. Martin, as many of you will know, is a senior member at the Permanent Court of Arbitration. And just a few hours ago, despite the fact that he is in The Hague, where the time difference makes it very late at night, he says he's caught up in a work emergency and wasn't able to be with us. The first topic, as I mentioned earlier, we're going to talk about is independence and impartiality. And if I could begin by asking Laurence, there has been a fair bit of discussion in the arbitration world, particularly in ISDS, but also in commercial arbitration, about conflicts of interest, about changing standards, about disclosure by arbitrators, and also particularly in ISDS about the concept of double hatting, or a person serving as both an arbitrator and counsel in different matters. Could you talk to us a bit, Laurence, about what has been happening and what trends you see in respect of conflicts in both areas of arbitration?
Thank you, Barry. Thank you, Charles, for the introduction. Thank you to the organizers for having me on this very distinguished panel. I'm certainly in good company to discuss this hot topic today. I think, Barry, as you say, certainly the independence and impartiality has been one of the most discussed topics these past years. Since 2017, when UNCITRAL seized the mandate for Working Group 3 on ISDS reform, it was quickly identified as one of the core reform efforts issues. So together with diversity and coherence of awards, independence and impartiality immediately was the focus of the efforts. Now, I didn't give much of an introduction, presuming that our audience is familiar with the concept. I have this beautiful quote that we all know, of course, from Lord Hewart, who wrote in 1924 that it is not merely of some importance, but it is of fundamental importance, that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Now, I know we've all heard this many times again, but it's also at the core of the discussion surrounding conflicts of interest and double hatting. ISDS has been under fire for over 20 years now, and subjected to critics for its lack of legitimacy. And one of the issues, as you mentioned, is stemming from double hatting. Double hatting, as you know, occurs when an arbitrator one day can be sitting on a panel and will be pleading before his colleagues the other day as lawyer. For many of you, this means that you now have practices as solely as arbitrators, or also justify the fact that the boutique law firms have popped up regularly. And even this week, I was watching the legal news, and we saw at least 2 very important arbitration practitioners breaking away from their major firms to be able to practice and not be impeded by conflicts of interest. The discussion, to bring it back at what happened at Ancestral, was quite difficult because the code of conduct on adjudicators at first and ultimately as adopted on arbitrators in July 2023 first required a complete ban of double hatting. Now, not everyone agreed with this because, of course, it would have an immense impact on their activities as arbitrator and counsel. As you may know, most practitioners do not have a sole practice as arbitrators, but will likely work within the two roles for some time, if at least to be trained. And this has been the argument for some time by arbitrators who consider this not to be such a problem, that lawyers who wish to become arbitrators, just like in many legal systems where lawyers will come to the bench after a number of years in practice, need to be trained and need to have the opportunity to learn how to be an arbitrator. The discussions evolved, and after about 5 versions of the code of conduct, to put it briefly, rather than keep with the one restrictive and slightly less restrictive version after every iteration, in September 2022, it was decided that the codes would be separated, with one for judges and one for arbitrators. And this really gave more leeway for the code of arbitrators to have a clear delimitation of double hatting. The ultimate decision that was adopted in the code of arbitrators adopted in July 2023 provides that, and I will just read it out to you so I have the correct, but there's a three-year limitation in most cases, and there's just a difference because there's a 1-year limitation in another. In general, this code as well extend the duties of disclosure of the arbitrator, provides new provisions for assistance to the tribunal, who will be required to sign a declaration of independence and impartiality, as is done now in most cases, at any rate in investment cases, and also provides new provisions on third-party financing. But just to give you the language for Article 4, what was ultimately decided, give me 1 second.
Or should I read it out? I think
Okay, I've got it. Oh, do you? The compromise for the 3-year limitation was that a former arbitrator cannot act as legal representative or expert witness in any other ISDS or related proceeding involving the same measure, the same party, or related parties, as opposed to the 1-year limitation when the same provision of the same consent instrument is involved. So this was, thank you, Janet. This was considered to be the apt compromise, which allowed the adoption of the code. Now, there will be consequences to this limitation, of course, with many lawyers who can no longer be available to act as arbitrators or may have to decide to work solely as arbitrators. Investors and governments also may have less choice in selecting the arbitrators of their preference, and it will make it different in access to arbitration for investors, governments, and the arbitration community. Diversity is a subject that we will touch upon later, so I will not discuss any of these issues, but it is also quite interrelated to the discussions. Aside from the code, 2 other reform measures might have an impact. The adoption of a multilateral investment court, which, according to some, the EU principally would guarantee independence and impartiality of arbitrators. Now, this is not the opinion of everyone. In particular, as was well written out in another book that came out recently, where Andrea Björklund also has a chapter on Canada, on the independence and impartiality of international adjudicators, prepared by Judith Cordero-Moss. There was a very complete study done of national country reports of independence and impartiality, looking at specifically whether a standing mechanism for selection and appointment or a multilateral investment court would indeed prevent conflicts of interest or resolve all pending issues. Now, the authors of that book are not so sure, and I think it remains certainly up for debate to see whether it will be a success or not. I'm keen to give sufficient time to start the discussion, so maybe I'll wrap up my remarks in discussing how this code was received, because it was the most discussed instrument and it was the first adopted instrument after 5 years of negotiation. Some were very enthusiastic about the code, and some a little bit less, with Jose Alvarez describing it as the lowest hanging fruit or the easy solution. Whether it's a success or whether it's merely an omen of difficult negotiations to come will remain to be seen. It took 5 years to come to these two instruments. There are other negotiators on this panel who may tell us that 5 years might be a very short time span for a negotiation or a very long one. Ending on this, I will leave the floor, I think, to Janet, who will discuss further. Thank you.
Thank you, Laurence, and thank you to everyone for the very kind invitation and also the very warm and generous introduction. Just to follow up on Laurence's points, indeed to embellish on those very excellent points, bringing in that sort of contextual comparison with international commercial arbitration. Of course, independence and impartiality are very important for both of those fields, and indeed the standards have been advancing over the years. But having said that, there is a special need in investor-state arbitration or treaty arbitration more generally for a concern about what might be described as issue conflicts. And I recall that this term was, the first time I heard this term was from Professor Christoph Schroer some 20 years ago, when sort of people hadn't really thought about it. There wasn't enough material out there. There wasn't enough collective experience to be able to recognize it as a significant point. And he said, you watch for it, it will come. And indeed it has come. And once again, just to sort of give the very basic explanation, with so many awards and rulings and decisions publicly made, many people can become sort of associated with a particular approach to what might be a very similar issue in other areas. And it is an obvious point to Professor Schroer at that time that if you were counsel in one case and you were arbitrator in another case, wouldn't it be helpful if the decision in your case as arbitrator assisted you in your arguments before a different tribunal on a very similar issue? At that time, there was insufficient public information to be able to sort of join the dots and track these through. But he was in a position to see that, and he could see it coming. Indeed, it did come, and it created what seemed to many to be a key source of concern for the legitimacy of international arbitration in this space. And indeed, you know, as Laurence has explained, this was one of the most significant and controversial features of the Working Group 3, and their code of conduct came down on side, as Laurence has said, for prohibiting acting as legal representative or as arbitrator in concurrent proceedings. And that's the sort of first step. And then there is the cooling off period that Laurence emphasized. Now, I just want to say a few words about the practical implications of this. And that is this. For those who are more familiar with commercial arbitrations, you might say, not that issue conflicts routinely come up in confidential proceedings in which there are very rarely the same provisions at stake and the facts create such variety of circumstances. But the conflicts themselves, if they are for concurrent proceedings, one might expect to sort of last for a year and a half, 2 years, perhaps not much longer. But if I dare say, in the glacial pace with which ISDS proceedings move, this could be many, many years. So simply the prohibition on acting in concurrent proceedings could in fact span a significant portion of one's career. And so it could be quite significant. Let me add to that the cooling off period would only increase that time in which one was barred from taking up a role. That particular role, that brings me to a point that's become clearer and clearer to me in recent years. I'm often quite wary of very strong statements about standards for independence and impartiality, either in one direction or another, because I'm often concerned to note the particular role and background that is currently played by the person who voices them. And so I'm quite cautious in saying this. I could very well say myself with some confidence, let's put an absolute ban on double hatting. Just that's the only way to establish any kind of semblance of integrity in ISDS proceedings. But someone would rightly respond to me, very easy for you, Professor Walker, because you do not serve as counsel or party representative. Indeed, that's a fair comment. And so what I want to say is it's important to be mindful of other people in the mix, other people in the community who might be affected differently by either a very strict approach or a very relaxed approach. And in particular, and I certainly don't want to steal the march on the next topic, which is such an important topic, but I look around and I say to myself, looking out at the council teams that I see, with the many young, capable, and rising stars among them, many people of a wide variety of backgrounds. And I say to myself, my goodness, if each and every one of those people is prohibited, not only for the concurrency of a particular proceeding, but for a cooling off period, from serving as arbitrator in a proceeding which, as we've said, has the same or related parties, the same provisions of the same instrument of consent, or is similarly excluded from serving as arbitrator. What a terrible restriction that will be on their ability to accept appointments. Once again, indeed, unlike a few of the stellar figures in this field, those invitations to serve don't come along on a weekly basis. And to find yourself conflicted out when you're just trying to get your career up and running could set you back or give you the feeling that you're being set back for many months, or in fact, perhaps many years. So how unfortunate is that? Beyond that, let me say also, it is true that if you pen your own dissent in an investor state matter, and it is a matter of public record, you are very clearly associated with a particular view on a particular provision. But if you're a member of a large council team, oh my goodness, how do I know what your own view is on that provision? Obviously, you have necessarily a commitment to a particular approach that best suits the party you're representing. What your own particular views are might be quite different. All of this is to sort of say in a very in a much more detailed way than perhaps is needed. The point up front on Article 4 of the UNCITRAL conduct for Code of Conduct for Arbitrators that provides that unless the parties otherwise agree, I hope will be used much more liberally than it might be considered for those who want to take a very strict approach to this for that reason. Again, I don't say it for my own sake, because indeed I don't serve as a party representative, and have not served as a party representative, and so I'm not at risk of being excluded for this reason. But I do say it for the many people that we hope will be in the growing pipeline to serve as arbitrators. I think I've said enough on that, and I'm sure there will be others who will have things to add.
Now, there's a question I have that I think we're probably, and Laurence has her hand up, but I think we were planning to block out about 15 minutes for each topic. So my suggestion, unless Charles Manuel has a different view, is we should move on to the second topic and save my question and Laurence's comment for the end.
Barry, actually, I would jump in immediately in the questions. If you can be concise, I think it's going to be more fruitful because we will have many other questions. So maybe we can borrow 5 minutes on our last Q&A period at the end, just to close the momentum.
Laurence?
Thank you for graciously allowing me to comment and question. I wanted to play a role which I'm no way fit to do, but that of Martindo, and present the institutional point of view a little bit, because on this topic it has an immense importance. Of course, our subject today is where there's convergence and divergence between investment and commercial arbitration. And although we've discussed the novelties, there are many things in the system which really separate investment and commercial arbitration. The way that the challenges are decided by institutions, mostly in commercial arbitrations, with a neutral party or an institution determining the challenge, as opposed to the very criticized system in investment arbitration, where the challenged arbitrator will have his or her challenge determined by the tribunal members, which is, of course, quite odd. So I thought I would throw it out there for discussion, because that is problematic, and it does explain why this subject has come under fire so often in ISDS. And I would add shortly that one thing that will help in the future is the increasing transparency of decisions on challenges and removals. I have the statistics, if I'm able to say it, which are unfortunately, or surprisingly perhaps, quite low. So both in ICC and ICSID cases between 2014 2019, the numbers revolve around 5% of successful challenges, with 14% of challenges in cases. So challenges will derail cases, take up immense time, be tactics sometimes, be justified, but are successful only in more or less 5% of the cases. So there's a question also to know what is the justification of these discussions of reform when really there's very little success to these challenges. And just to end, following around the time that the codes of conduct were adopted at UNCITRAL, the IBA, which provides for the guidelines on conflicts of interest, a traditional method to determine a conflict of interest in commercial arbitration, has also announced last April that they would be revising their guidelines. So I'm quite interested to see where ISDS reform influence bleeds into commercial arbitration and wraps maybe our topic. So these were all my remarks. Thank you.
One aspect of what you said we'll come to when we get to our third topic, which is transparency, and the fact that the ICC and other institutions in commercial arbitration are publishing challenge decisions. And so there will be more information out there, which who knows what it will lead to. Hopefully it will at least lead to greater confidence in the process. Something else you said, and I don't know if anybody wants to comment on it before we move on to the next topic, and that is whether there are rising standards of disclosure by arbitrators, either motivated by the fear of challenges motivated by institutional rules, by court decisions, which we've seen in Canada, in the UK and other places. Andrea?
Sure, I think you're absolutely right, Barry. I think there are both rising standards related to disclosure and greater, maybe not quite uniformity, but greater uniformity about accepting greater disclosure. So in the revised, ICSID revised its arbitration rules in 2022, and they require much more disclosure than had been the case before. And the code of conduct at UNCITRAL now requires or suggests quite a lot of disclosure. I think now they have a slightly, let's say, modified view. There was in version 2, I think it was, of the draft code of conduct, in my view, was a terrible. Thank heavens we didn't end up there, but I would say it wasn't a code of conduct at all. The entire code was disclose everything you've ever done, and then we'll see if anybody challenges you. And then you'll know whether what you did was okay or not, because we'll find out once they challenge, and if they challenge, and what the challenge decision says, which seemed, when I say literally, backwards, and I could be more probably vulgar about that, but just seemed like completely, talk about a missed opportunity. So I'm delighted that we did not end up there, however much I'm in favor of disclosure. But I do think there's an increasing acceptance that, I don't know, of what I take to be perhaps the North American view that sunshine is the best disinfectant, disclosure is an insulating practice, whereas I feel that across the pond, there has been, and perhaps still is, a little residual sense that, well, if you disclose, it must be because there's something that you need to disclose, as opposed to doing so in a prophylactic sense. But I think some of these changes are eroding that difference.
And then there's sometimes the view that if you don't disclose, that itself is used as a basis for disqualification, even though it's something that may not have otherwise been disclosable.
Yeah.
Anybody else want to comment on this before we move on to our next topic? Charles Emmanuel, it's over to you.
Yes, and I think we, both Janet and Laurence, have alluded to the clear link that there is between those two topics. And the question that popped in my mind listening to you was, do we sacrifice diversity on the altar of independence and impartiality, reducing the pool of people that can be or can support a practice of full-time arbitration? And it leads us to this second topic of diversity, which can be explored under different angles, whether it is gender diversity, geographic diversity, age diversity, expertise diversity, north or south origin diversity, etc. So I would like to now invite Louise Barrington to say a few introductory words on that very important topic.
Thank you, Charles-Emmanuel, and thank you also to ILA for the generous invitation. I'm very happy to be here and joining you all. Diversity is one of my, I guess, one of the themes of my career professionally, and I want to take you back a long way, and this will date me. But I had my eureka moment where I decided that I was very interested in arbitration and doing arbitration in the late 80s when I was doing my master's, and Emmanuel Gaillard was talking about arbitration and the Pyramid Plateau case, and I thought this was fascinating. Well, I got a chance to actually do something about that a couple of years later in 1999 when I joined the ICC. Not with the court itself, but with the Institute, which is a think tank. And that was a wonderful position to not only meet all of the gods of arbitration, but also to learn a huge amount from them about how arbitration happens and the things in the corridors, as well as the procedures themselves. Anyway, back then in 1991 or so, I went to my first conference in Bahrain. ICAO had a conference there. There were about 240 people, and it was actually rather diverse, because instead of the usual room full of gray suits, white shirts, and somber ties and gray hair to match, if there was any, there were actually people from the Middle East who were wearing jalabas and other national dress. But that was really quite an eye-opener for me to see that everybody there was male and almost all white, and of a certain age. The women at the ICC, there were 2 women who got regular appointments time after time. And so when I first began to wonder about where the women were, and did a study, and was then asked to present the results of that study, my then boss, Pierre Lalive, one of those gods of arbitration, was the moderator, and I'll never forget overhearing him at lunch saying, "I don't know what she's going to talk about. Where's the problem? Well, there are no women in arbitration, but where's the problem?" It was simply a matter of no one had ever thought about it. It had grown up among experienced men who chose each other because they trusted each other. And it was a very small group. That was in the 1990s. And the proportion of women who received appointments at the ICC at that time was about 2%. Now, things happened after that. We began Arbitral Women in 1993, which was really just an informal group of women who wanted to share their experiences and maybe learn a bit. And then we became incorporated in 2005 or 6. And then in 2000, at that point, in 2006, there were about 20 of us, I guess. And a lot of people refused to join us. A lot of women said, "I don't want to join you because I'm afraid that it will hurt my career. If I am seen as joining a women's group, people are going to think that I'm some radical bra-burning feminist trying to make revolution and take the jobs from the men." Then there were the more dangerous ones who said, "Well, I can make it by myself. I did make it by myself, so everybody else should be able to as well. So why should I help?" Anyway, in that same year, 2006, there was a conference of the ILA in Toronto. And Janet and Barry were the co-chairs of that conference, and they did something revolutionary. They had a seminar called The Changing Face of International Arbitration. And that was, to my knowledge, the very first time that any international organization had acknowledged that there was a problem here. So we can all thank them for starting that ball rolling, and it's been going ever since. Now, I think it was 2017 when we had news from the ICC that their statistics had gone to 27% of the women of the arbitrations were appointed, women appointees, which was amazing news at that time. Janet, I think you were the one of the members of the only all-female arbitration tribunal. Around that time, I don't remember the year, but you may.
ICC, the first ICC all-woman tribunal was in 2004.
2004. And it made news all over the place. And this was before the internet was really big the way it is now, but everybody knew about that. So anyway, now things have changed. I'm trying to get rid of this. Sorry.
I think Barry was
Anyway.
holding up the picture of the
So now
the-
today, the reason I went back in the history is because I think it's really important for people who were not there at the time to realize how hard it was then. When I went into arbitration, I had no clue how hard it was. I didn't realize that women weren't supposed to do that. But then I was repeatedly reminded of that for many, many years. But due to the efforts of a lot of people who also recognize the problem, it's now become good news. It's become something that everybody's talking about, and I think the diversity movement has spread like ripples from women, because we were there, we were vocal, we were countable, we were visible, to all the other different kinds of diversity, race and geography and age, and sexual orientation, expertise, as Charles, Emmanuel mentioned, and others. I think that the diversity movement is based on the fact that there's now a recognition, which just didn't occur to anybody before, that diversity is a positive thing. It's a challenging thing because we do tend to want to deal with people who are like ourselves because it's easy. But the challenges that diverse groups present make us look at our own values, question our own opinions, and also defend our own strategies. So everybody knows now about the business the business model with the diverse board, which is more profitable and makes better decisions, etc. And I think that most people realize that is now, those same premises work in a tribunal and also in council areas. But what I'm seeing now is that the group of people that is available is so broad, and that is something which I think is necessary for the legitimacy of arbitration, because the people that are doing international business now are from all over the globe, and they want people that look like them to be on the tribunal. They want people that share their backgrounds or their cultures on the tribunal. So I think we've come a long way, but because it's hard, because diversity is the more difficult path, it's so easy to slip back. And so we have to make sure that that doesn't happen by continuing to be vigilant. I think that just a word on the institutions, since Martin isn't here, but I think the institutions have been fantastic at this. They've realized that diversity is a selling point for their own brand. And so the institutions have been making real inroads into making sure that diverse groups get nominated. And I think they have a lot of credit for that. It's self-interest, of course, but they also deserve a lot of credit, because, of course, the argument when I was with the ICC was, well, we don't want to nominate, or we don't want to name an arbitrator who's unknown, because we're the ICC, and what if it's not somebody good? And that will affect our reputation. And I think they've now become brave enough, because they've had to take that risk, and it's showing up. I think I should stop there. We can talk about other things as you wish.
Thank you, Louise. And I could not, before passing the floor to both at first Janet and Laurence, that have indicated an interest in the topic, I cannot help but noticing that the push for diversity, not for gender but for culture and geographic and culture, is embedded in the statute of the International Court of Justice since day one. This idea of legitimacy and diversity of the bench, and of quality of the decision, and of reading law in different legal traditions and in different languages. It's embedded in the judicial at least the judicial settlement of international disputes. Maybe Laurence or Janet, would you like to comment or continue the discussion?
I think Laurence was listed first, but I'm happy to jump in.
Go ahead, Janet. I'll go after.
So can I just ask, is it possible to enable screen sharing?
Una, maybe you can help us with that? I think you can authorize Janet to have this function.
Oh,
Yes.
yes.
We're all waiting with bated breath. I think
It'll be worth it.
you
I know
just
what you're
make me
going to share.
just make me a co-host, Una.
Okay, you should be able to do it now.
Yes, indeed. All right. Good. So you should be able to see this image now. And this is the group. And it's sort of become masked for me. So I'm hoping that I can recall from memory who is in this group. But it was a wonderful group. You see, I won't say a very young, but on the far left you see Barry, far right you see me. But you can see it's quite a variety of people there. And for 2006, it was really quite brave. When you look actually at the people who are there, I think, oh my goodness, so many years later, and how many of those people do we continue to work with? Fei Ning, from China, Karl-Heinz Bockstiegel, obviously, many people know her. Deborah Enix-Ross, who is now heading up the ABA. Marc Lalonde, who sadly has now recently passed away. David Roney, based now in Switzerland. Claudia Salomon, many of you will know who that is. Anne-Marie Weitzel, who was also very much a leader in the ICC and now is is a professor in the United States. Look at Louise there in the front row, and my goodness, and many others with the AAA and Larry Newman and others. So Richard Nairn, and so we see many people who've continued in very strong roles. I will stop the share now so as not to take up too much time, but it was a wonderful thing. And I must say, one of the things that I thought that in retrospect has so impressed me about that was that, in fact, the person who led the charge on that was actually Barry, and I take my hat off to him. And so precisely a person who would not, in a demographic, who would not have been in need of advancement through the promotion of diversity, was indeed very much a champion of diversity.
And Janet, so for anybody who wants to have their own copy of that photograph, because Marc Lalonde is in it, and because the Canadian Journal of Commercial Arbitration is doing a special issue, as you know, coming out soon with tributes, remembrances of Marc, this picture is going to be published in there. So you can have
so
a copy.
Nice. No, to just sort of bring the commercial arbitration and the investor-state arbitration together in a kind of compare and contrast. One of the challenges, that Louise mentioned about diversity is getting people to appoint someone knowing that they are going to be answerable if things go wrong, to put that in a very general way, knowing that they're going to be answerable to the person who has retained them or given them that role. Just imagine how that multiplies itself in investor-state arbitration. And I say that for two reasons. One, because the accountability, and we'll talk much more about this in our next topic about transparency, but the accountability is not limited to private parties. And so So that's one sort of dimension in which it extends, but also it extends because so much is, in any event, so much more public about investor-state arbitration. So if something does, quote unquote, go wrong, and as I say, I'm saying that in a rather ironic sense, because just having an unfavorable result might be considered by some to be going wrong, even though there's nothing wrong with the appointment or the process. But that also ratchets up the pressure. And so it's a very sad comment to say that I do recall speaking, frankly, in many years gone by, with people who are considering, shortlists for arbitrators for appointment, and having discussed with them the many wonderful and glowing qualities of many of the people who might be on the short list, and having them say, well, at the end of the day, we need to know that that person is going to be in our corner, and it just sort of sends them back to the usual suspects, So I do have a lot of sympathy for the challenges that are faced by people appointing. Yes, Louise is absolutely right. The institutions, I give them a lot of credit. They stood up, and they've really sort of taken on the challenge, and have been in a position to be much bolder than many others who are in the role of appointing people. But let me say that just as gender diversity has led the way for many other kinds of diversity, so might I say has international commercial arbitration led the way, in a sense, for broader diversity in ISDS. And I just want to give some words of encouragement to say we are actually, dare I say, making progress. So I am aware of the first all-woman ISDS panel, and that was in 2020. I think there was one published on GAR, but it wasn't actually the first. But in 2020, this tribunal was appointed. And can I say, with also a tongue-in-cheek, that I'm also aware of the first all-Canadian ISDS panel in 2023. I'm not sure if that's a milestone for diversity, but it's something that allows us to cheer on Canada, which is kind of a nice thing. But having said that, let me say that as in this sort of glass half full view of the world, the thing that I think is the most promising thing that I see in both commercial arbitration, but also in investor-state arbitration, is to see that the pipeline is building. And let me talk to you about the evidence that I see of that. First, in the Canadian arbitration report on which Barry and I worked, and which many Canadians generously contributed their time to developing. The full report is yet to come out, but the initial indications from the report are that almost 2/3 of those who are based in Canada as arbitrators had as their professional formation, if you will, their background profession, that of serving as lawyers and as counsel in arbitrations. And so what does that tell us? That tells us that if we look around and we see greater diversity, gender and other diversity among the counsel who are appearing in arbitrations, that bodes well. Now, again, I know there are sort of hiccups and gaps along the way, and there's no assurance. But if indeed 2/3 of the arbitrators used to be, or in some cases still are, but began their career and served most of their career as counsel, then indeed I think that's a promising sign. And I will say, just very anecdotally, I see this very much more and more in cases where juniors on the team are being given important roles in cases. It's not all the advocacy is being done by the senior counsel, and indeed just within the last few weeks, in a large procedural meeting in an ISDS case, saying at the beginning of the meeting, would the teams be so kind now as to invite their colleagues who will not be speaking to turn off their cameras so we can clear the screen a bit and be able to see who is speaking. And indeed, all the cameras went off, but the tribunal and 4. And I looked around and my first reaction was, oh, this is a bit awkward. Have 2 counsel forgotten to turn off their cameras? But I was wrong. There were the 2 lead counsel, but indeed there were 2 members of their team. I will add both women, and not of a single of a unified other background, but of diverse backgrounds in other ways. Both of them on the screen, and indeed they had a role to play, an important role, each of them. So once again, I see that as sort of, you know, proof, at least for me, anecdotal proof that in fact the pipeline is building, and I see that as an encouraging sign for the future.
Thank you,
Now,
Janet,
I'll shut
for
up
this.
now and let others say very valuable things I'm sure they have to add.
Thank you very much. For the sake of time and of covering our other topics, I would like to ask now Laurence to make her comments and to do it in a concise way, if possible. Thank you.
I will try to do so in the briefest of manners. I see the time running. Of course, our expert here, I would like to hear from as well, maybe in the Q&A, is Andrea. And I refer specifically to, yes, the one of the reports that was so interesting on diversity at UNCITRAL Working Group 3. And it was so interesting to me to hear of the diversity arguments. Sometimes I think of it, I wrote it down as the diversity sword, which I don't know what it means, was yielded both ways. It was used as an argument, both in saying for a multilateral investment court, that it would aid in obtaining greater diversity, but that it would also block it. And there's an argument to be done for both. And I also want to reference, there was an interesting article that came out on this CEDA's list of arbitrators, titled, and you know where I'm going, it's CEDA, Where Are the Women? And Catherine Simpson, and an author, and I'm sorry I forget the name, because both authors did a wonderful job, attempted to see why the list for CEDA's tribunal would not could not include more women, or would not at least be equal. And they essentially, within I think 10 days, managed to find more than enough women who were available and qualified to, of course, act as judges or be appointed as members of the permanent court. My time is running very short, so I wanted to mention 2 important things. One is that gender, of course, diversity goes hand in hand now in all the articles and the literature and the discussions with origin and all diversity issues. They're really intersectional issues, and we see the impact of one on the other. And I think it's agreed that we have to consider them together. I recently forayed into sports arbitration, and I know this is outside of our topic, but I will be very brief. The numbers are even more dire in sports arbitration than they are in commercial and investment arbitration. The women are simply barely on the arbitral tribunals, whereas, of course, they are there and available and competent. And in this research, the point that Janet was making and that Louise was making is that, of course, the institutions have been wonderful and have a great role in appointing arbitrators who are from a diverse background, but the problem continues to reside with the clients and those who appoint arbitrators and have a much harder time being convinced to appoint someone who is perhaps less known and perhaps not in the regular club of appointed arbitrators that we see. So I will leave this subject there, and perhaps we cover it later in Q&A.
Thank you so much, Laurence. And I guess one question, and we don't have time to answer it right now, but that comes out from this discussion is: would we need rules to promote diversity even more, or will it happen like that? Or maybe if you want to quickly maybe comment, just because I saw your reaction, please, and then we'll pass on to our third topic with Barry, but maybe comment on that. Do we need rule to force it or not, or perhaps?
Well, in French, the word is frileux. Many institutions have been wary of including direct rules in requiring, for example, gender equality. The ICC asks in its note to parties and tribunal to consider the diversity, and it is passed on to the nomination committees. So that's something, but it's still not written black and white. I would hope so, and perhaps this is the way. I see Louise.
Thank you, Laurence.
I was just going to mention that the Scottish Arbitration Association, I don't know whether that's the actual name of it, but their most recent rules from last year, I believe, have a rule saying that there will be a consideration of diversity. So there's no standard, but it is to be considered in appointing arbitrators.
Hopefully we go to parity, or sorry, but
I was just going to say, unfortunately, Scotland has no cases, so doesn't help the cause that much.
No, but it's a good idea. The fact that someone's done it may encourage other arbitration institutions to do it as well.
And I think it's becoming an unwritten rule that you can't have a short list that lacks diversity. And so even though it's not an absolute, requirement, I see even among the most sort of traditional, usual suspects, a reluctance to go forward with a short list, at least a short list, that doesn't include a diverse group of people. And I think that's a good sign.
Thank you. Barry, I would leave the floor for you to introduce our next topic, transparency.
On the area of transparency, and we touched on it earlier, there's really, and hopefully we'll get to cover, two kinds of transparency. There's transparency of the process and transparency of the outcome. And transparency is something that historically people talk about arbitration being private and confidential, and as those who are involved in arbitration know, there's a divergence on confidentiality. But this move towards transparency appears to be something that is occurring in both commercial and certainly in ISDS, and an area in ISDS where I think Matt will be able to tell us Canada has been a leader in pushing for it over the years, going back to his reign. So can you talk to us a little bit about, starting with Matthew Cronby, the transparency as you've seen it in arbitration?
Yeah, sure. Thanks, Barry. Thanks, Charles-Emmanuel, and everyone else on the panel, and those who have decided to take a couple of hours out of their afternoon to listen here. I was actually going to break transparency into three categories, not two, because I would include, in addition to what you refer to as outcome transparency, or might call also legal transparency, in the publication of awards or tribunal decisions of other sorts, and so forth. And then the procedural transparency in the form of things like access to pleadings, open hearings, the kind of institutional or operational transparency that we were just talking about a little bit earlier, with respect to things like disclosure of arbitral appointments and reasons for removals or the fact of removals and the like. So I'd break it into three categories. But I think it's absolutely clear that legal transparency and procedural transparency, most notably, have been increasingly incorporated into the ISDS system. I mean, I don't think anyone can doubt that, whether it's through things like treaty rights, and you see it in Canada's 2021 model bit, things like stipulation that hearings and documents from the proceedings have to be open and available to the public, subject, of course, to the usual protection for things like business confidences, provisions in other treaties, plurilateral agreements like Article 924 of the TPP. These things are increasingly commonplace and no longer very controversial. Certainly had countries that when Canada was first promoting some of these ideas were really adamantly opposed to greater transparency. This was true both in investment arbitration and at the WTO, where there was a parallel move towards greater transparency. And then, of course, you see it in things like multilateral rulemaking and conventions. We've got, since 2014, the UNCITRAL rules on transparency and treaty-based investment arbitration expanded under the Mauritius Convention. We see it in amendments to the ICSID arbitration rules, just last year, also making publication of submissions and awards and holding public hearings with the presumptive or default mode of operation. And I say this is increasingly the norm and is no longer especially controversial because the rationale is strong for it. You've got the fact that in ISDS cases, and particularly treaty-based ISDS, disputes that concern matters of public interest or societal concern, for example, operation of environmental or other regulatory law within a country. You've got the fact that the outcome of these cases can be significant, sometimes very significant damages awards paid out of the public treasury. So these all raise questions of accountability that Janet alluded to or when we were discussing earlier. But equally, these cases involve interpretation and application of public treaties between sovereign states, and therefore, at the very least, the stakeholders in those states, and some would say more broadly too, contend, and I think legitimately, that they have a right to see the processes and the outcomes of those disputes. And I'm not even going to get into the whole issue of procedural rights, or participatory rights rather, which I consider a somewhat distinct issue, but sometimes seen as an adjunct to transparency. And there is the view that these considerations should and do override one of the traditional features of arbitration, which is the confidentiality of the proceedings. But I think we're well past that in ISDS. And the more interesting question is, how far should that go, and do those rationales hold in commercial arbitration? Because there's been calls for more transparency there too. But I don't think the case is as obvious. I'm not saying there isn't one, or there isn't a good one to some extent, but it's not as obvious, particularly in disputes between private actors, where these cases typically don't involve matters of public interest or potential payouts of public funds. And I'm leaving aside things like investment contract disputes with sovereign states, which are sort of a hybrid. But in pure commercial arbitration, confidentiality isn't generally seen as a bug. It's one of the key features that makes arbitration an attractive alternative to litigation for many of the users. And since arbitration does ultimately require consent of the disputing parties, it's I think harder to make a broad case that there's a compelling reason in commercial arbitration to override the desire for privacy or confidentiality, particularly if the law that's being interpreted and applied is that of a private commercial contract, not a treaty, or not even a public contract. And I think some of the transparency initiatives we have seen in commercial arbitration reflect that important distinction or difference in rationales, because they are focused more on what I've called the operational or institutional side of transparency, less so on legal or procedural transparency, not entirely, but less so. So there has been a movement, and we've seen as Barry noted in, for example, the ICC, for disclosure of arbitral appointments and reasons for removal of arbitrators. We've seen requirements to disclose the existence of third-party funding and identity of funders, not so much details of funding arrangements for good reason, but we've seen that in the ICC, ICDR. Of course, that's also happening in investor-state dispute settlement, but that needn't affect the confidentiality of the proceedings, and it does offer benefits that I think Janet referred to when we were talking about the first topic about independence and impartiality, because those kind of initiatives do help identification and avoidance of conflict and improved arbitrator selection. But we are seeing some move towards what I call legal transparency. And for example, the ICDR, through publication of awards with the consent of parties, publication of anonymized awards or summaries. And the principal rationale there is that it increases consistency and predictability, develops a body of law. I don't think it's just for you full-time academics to have something more to write about, although maybe that is one of the rationales. The other rationale, though, is that I've seen is that it helps educate practitioners as how arbitrators interpret and apply law, the kinds of arguments and strategies that are likely to prevail. I think those are all good rationales. It may also help businesses avoid disputes if they have an insight into how those disputes, if there are like disputes that they can point to in case law, are likely to be resolved. But I come back to the question of, well, but with respect to what? Common contractual clauses or terms? Those are less likely to arise. Certainly they arise for sure, but less likely to arise than in a treaty context where you absolutely have the same sort of provisions that are interpreted again and again in the same treatments. I mean, name an ISDS case that doesn't involve a fair and equitable treatment claim or a national treatment claim. So it does make sense in treaty arbitration where these kind of applicable, the applicable laws or the obligations are relatively consistent, even though there can be divergence in how they're expressed among treaties. But I think it's somewhat less clear in a commercial context. And my question here, and maybe this is a good time to turn it over to Janet, is how far should it go? And also, to what extent should arbitrators, to the extent we're building a body of case law, to what extent should arbitrators be following prior decisions? Because I will note that even in a public law context at the WTO, there has been a pretty strong pushback, and it's one of the reasons why there's been this crisis in dispute settlement at the WTO against attempts by the appellate body there and to assert a system of precedent. So my question is how much of this really is relevant in a commercial context? Over to you, Janet.
Thank you so much, Matt. And I note you are very patient, almost 70 minutes in waiting to speak. Oh. And can I say that, and I'm glad we got a running start at this topic, because I think it is actually the trickiest of the three. And you've hit the nail on the head, Matthew, when you say, how far should we go? And I say that it's the trickiest because although there are countervailing considerations and balancing issues in respect of independence and impartiality, and in respect of diversity, less so in respect of diversity, very much in the question of transparency, there's a real sort of complex series of tensions that play out in that issue, and we're seeing them play out in practice. I don't want to go on at length about commercial arbitration. I did speak about that at the last ICA Congress, and I'm not going to invite you to go and look for the paper, but that was really the sort of the theme of my discussion, and it's really quite a complex issue. So some of these things, ICC panels, appointed, and disclosures, which are kind of accountability and transparency. Those things are kind of much easier to manage, but very interesting to see that the SIAC and the ICC promise to publish awards, or should I say threat to publish awards, has really not emerged as a reality. And you kind of wonder why. And all I can say, the very simple answer to that is, at the end of the day, in commercial arbitration, it is the party's process. It is a contractual process. And I don't want to try to draw a hard line between that and, which doesn't exist, between that and issues of broader public relevance. But where it is very much a private dispute, then it is up to the parties. And it seemed to be, may I say, a restriction on the capacity to conduct the arbitration as fits the process best. But coming on to now, did Louise want to jump in there for a second? Because I do want to speak about investor state a bit.
Just one word following your comment about the party's choice. I think that there may be some reluctance on the part of the institutions to make good on that promised threat. Because I can see that if the parties are upset enough about the fact that their award may be made public in some way, which may or may not be able to come back to them, that they'll simply not go to an institution that is going to do that. The arbitration was invented by commercial people because it met their needs better than courts did. If it doesn't do that, including the need to be private, then they're going to invent something else.
And I think in that spirit, we sort of acknowledge commercial arbitration to be, in principle, private. And in part for that reason, we also are much more willing to accede to a common interest for confidentiality, even if it's not otherwise assured. If the parties agree to that, we tend to think that that's okay. Less confident about that conclusion. And rightly so, I think, with investor state arbitration, because of the wider public concerns that Matthew's been speaking about. And so just let me just pick up on a few points that were raised. And that is, indeed, I do think that there is probably a difference between what I think was described as participatory rights, if that's what's spoken about as transparency, and informational rights. The ability to be informed of what is going on, and to be, for the tribunal and the parties to be accountable in that sense. So I won't sort of belabor that point, except to say that even though the establishment of the basis for the arbitration in the treaty might be one thing, when it actually comes down to a dispute, the participants in that dispute need to get on with the dispute in the way that reflects the sort of greatest integrity of the process, which encompasses a variety of things. In that regard, let me say that it's very interesting to see that the Mauritius Convention, we're approaching now 10 years, and it's not a uniform take-up. It's not a full steam ahead by a long shot. And we do see, just to put a little nuance on that, the idea of publishing sort of benchmark information, the tribunals, the names of the parties, and so on, is one thing. But to provide for the ability of non-disputing parties to make submissions for the publication of witness statements and expert reports, publication of transcripts, and the decisions, the internal decisions, it's quite a range of degrees of acceptance and willingness on the part of the parties. And I want to stress here the parties, not just the commercial parties, but the state parties. And they both have varying interests in that. And so far from it being, and I could say this, from my own experience, far from it being a comfortable cabal of insiders wanting to sort of do their whatever, backroom adjudication of the dispute, the tribunals are actually receiving submissions about the varying wishes of the parties to have these sort of factors made public. And it is quite a variety of interests that are displayed. So let me just point to, just to try to put the high level issues on the table for, I'm sure, what might be further discussion. In the UNCITRAL rules on transparency, it does provide that where the tribunal has discretion, the tribunal needs to be aware of the public interest in transparency in treaty-based investor-state arbitration and in the particular arbitral proceedings, and the disputing party's interest in a fair and efficient resolution of their dispute. Now, those two considerations can often be very much in tension with one another, and they do need to be worked out in the best way possible in each dispute. So I do think that provides for some indication of the potential complexities at stake. But Matthew's got far more interesting things to add to that. I'm sure Laurence as well.
Yeah, maybe Laurence wants to go first, and then I can jump in.
I have very different points, so maybe you want to answer. I'll let you jump in.
Okay, I just wanted to respond to one, and I think one of the good points that Janet made about the degree of take up, and that for a lot of states, certainly when I've talked to state officials, and I think the same thing holds true in a state-to-state dispute context as in an investor-state dispute context, what they're concerned about is not so much the transparency with respect to the subject matter of the dispute, although sometimes that is the case. They don't want those issues aired in public, but it's kind of a shyness. It's an uncomfortableness pleading these cases in front of an audience, including a national audience. They're not used to it, and they're really reluctant to do it. Those of us who come from a North American tradition, or sometimes European tradition, for example, or who come from the practice of law where we have been advocates and are comfortable doing this kind of thing, may see it differently. But for officials who don't have a lot of experience engaging in advocacy, they're not comfortable so much with it in many cases, and that's sometimes the motivation for the resistance. That might be a segue to the final topic on inequality of arms, but we'll get to that later. Over to you, Laurence.
If that's not a perfect segue into what I was going to say, I couldn't say. I wanted to comment on Canada's practice of having full transparency, and one of the things is having an open hearing, and a hearing where you, as a young lawyer, are aware that you are pleading not only in front of a very distinguished arbitral tribunal, a very distinguished opponent, and apparently a lot of people watching online, can be a little bit nerve-wracking. However, it is a fantastic and unparalleled insight and opportunity into the workings of an investment tribunal. And that would be the case for any young lawyer, but for any seasoned lawyer or any arbitrator who wants to know how the tribunal is directed, how the tribunal is reacting. Anyone thinking to appoint a certain arbitrator would, greatly benefit from having this. And I think overall, it's a wonderful practice. My other point was slightly different, and I know Louise wants to talk about artificial intelligence, but to me, there is a link between the transparency and artificial intelligence. And we haven't yet spoken about Jus Mundi, this fantastic research that facilitates access to commercial investment and sports arbitration. But that will also have an enormous impact on counsel and arbitrators and the preparation of their cases now that it's so much more easily available. I understand that they would not put any documents that are not openly disclosed by parties, that would be confidential, but that they had obtained through other means. But it is still, I think, something very important in building the precedent or case law referred to both by Matthew and Janet. And lastly, I had a small point about the ICC. Louise was telling us about her experience at the ICC, and I worked there between 8 and 2012. And a big part of our role was explaining the ICC practice to parties who were very puzzled and whom, when they were not the usual suspects and knowledgeable in arbitration, really had no idea how to manage their arbitration. And I think the ICC has come a tremendous way, just as other institutions, in opening up about its practice, in writing documents, in having the note to parties and tribunals, and explaining really what these famous practices are. And one of these things is allowing for publication of an award and publication of challenge decisions. Now, we haven't seen that many of those, but there's the possibility to do so. And that is such a huge step that, it makes me confident we'll have a greater and more interesting body of case law that we can build upon, especially in commercial arbitration.
Yeah,
So if I could just jump in on.
sorry, Janet, I'm going to suggest that we move on to the next topic and then invite Charles to lead us through it, because time is marching on.
Thank you, Barry. So we had asked Martin, though, to talk to us about the impact of the different types of parties on those issues that we're exploring. So maybe we can just a few words on that, and Andrea agreed kindly to say a few words about that. But what we had in mind here, and it's actually the fact that, and it touches on the transparency issue, notably. The spot is on ISDS, and when we talk about ISDS, we refer to treaty-based arbitration, right? And so what is really attracting a lot of attention is not necessarily that the state is a party to the arbitration, but that the arbitration involves the state and the treaty obligations of a state. But there is another type of arbitration that involves state, and that is far less under the spotlight of all these criticism, and it's state contracts arbitration, which is probably a hybrid. So you have mixed parties, but you also have the commercial arbitration aspect. And I'd like to ask Andrea if she has a few comments to make on that, and maybe explain why this is kind of out of the spotlight, this whole field of arbitration where states are parties, but the arbitration deals with the contract, and why is it not? Is it because it's just ignored by civil society movements and politicians and etc., or are there more substantive reasons why there are less reasons for that? Andrea, maybe you have a few comments on that.
Sure. So, we talked a little bit, I think Matthew mentioned a little bit the so-called, what we could call hybrid arbitration, which is to say investor arbitrations involving investments, but that are deemed commercial because they occur they are decided on the basis of private law. They are not a treaty dispute. They're often confidential because they tend to be lumped with commercial arbitrations. But I found for years, I found it puzzling that the vociferous critics of investment treaty arbitration seem to have zero interest in contract arbitration. I think that is changing, by the way. I think that is finally changing. It seems to me misplaced, if you will, if you're concerned about important public resources having a very a significant place sometimes in the national economy. And if you have dispute settlement about contracts that dispose of the rights to exploit those resources, that strikes me as raising the same types of concerns about public interest that stakeholders can and should be aware of. I don't have, so I think, I guess I would say they should be as transparent. One should be as interested in those contracts. I don't have a good real answer, Charles, about why this has not been interesting a lot to critics, except for the probably relatively obvious that often it's technically a state entity as opposed to the state. So that is sometimes seen as different. And indeed, as we know, sometimes that is different. Sometimes you might say it really is a private dispute between two entities about their commercial relationship. I think there are still these bigger implications, but it could be that the dispute is really, you said you do this, I said I do that. We didn't, somebody was supposed to hire the experts to do the assays and they didn't, and then we didn't have this, so it really is more of a commercial dispute even amidst this overlay. Yet other times it really seems to involve, and in fact most of the time, or at least most of the time we know about it, seems to involve often some kind of state action or some kind of change in state policy with respect to this contract, and often it raises issues about the contract itself. How did this contract ever get signed? What were the terms? Were the terms reasonable and fair? So I think we are seeing increasing focus on those issues, but it also has to be said that the more investor-state dispute settlement is under attack and under scrutiny, the more likely it is perhaps that states and investors will seek to have contract-based arbitration, potentially with provisions about confidentiality that kind of evade public scrutiny. So that is, I think, a space to watch.
And just would you observe such a move so far, or it's more of an impression that you get, or have you observed?
I don't have data. I would not say I have data that particularly supports it. I think it's more just logic, I suppose.
Yeah. Thank you, Andrea. And that leads us to our last topic, because talking about state-private party raises the issue of the equality or inequality of arms, but that issue may be also salient in private-to-private parties. So Barry, I will pass the floor to you for that last topic.
Thanks, Charles. The subject, at least from what I've been hearing, has been getting increased amounts of attention. There was one virtual global conference, I think it was the Institute for Transnational Arbitration, where there was a huge amount of discussion about developments that are, and there's always been inequality of arms in all dispute resolution. But is it becoming more of an issue and more problematic? And so perhaps, Matthew, if you could address what you've been seeing and reading and hearing, and where are we going? Got on mute.
Mike, can you hear me now? Yeah, sorry, it was saying the host had muted me, and I wasn't taking it personally, but so again, I think it's important to start by spending a couple of minutes talking. Well, what exactly are we talking about with inequality of arms? Yes, absolutely, it has been an issue and always will be an issue in any form of dispute settlement. not only in arbitration, not only in investment arbitration, but also in commercial arbitration. But we're talking about situations where there's an imbalance in terms of institutional power, access to information, legal representation, quality of legal representation, resources that a party could muster, or expertise in this case arbitration. And obviously that can significantly impact the less well-armed party's ability to effectively present its case, and ultimately can become a question of fairness or access to justice. But one of the things that's interesting is if you look back at how this issue was first, or one of the earlier discussions on it in ISDS, certainly one of the early ones that I found, it was Thomas Valde, the late Thomas Valde, talking about it over a dozen years ago, where his focus was more on the states being the well-armed party, and the investors suffering from the inequality, rather than the way it's often discussed now. So he was talking about the greater resources of states, especially relative to smaller claimants, their ability to abuse procedures, to maximize costs and duration of proceedings, wear down claimants, the abuse of states' coercive powers to intimidate witnesses or counsel or arbitrators, and even suggesting that if taken to its logical extent, that could give rise to its own set of investment treaty claims under obligations like fair and equitable treatment and full protection and security. But he also talked about, and I thought this was interesting, the ability of states to mobilize opponents, including NGOs or other domestic stakeholder groups or advocates, and including through things like amicus participation, but also outside of the arbitration itself, as exacerbating this inequality. And I'm thinking about this in the now familiar concept of social license. Well, that you think about that, that's potentially fairly powerful. But when you look at where the focus is now, there is, and you look at, for example, what's been going on at UNCITRAL in Working Group 3, a lot of the focus has been on helping bolster states' ability to participate in investment arbitration. The reforms discussed in Working Group 3, to the extent that they relate to this issue, really addressed perceived inequality that disfavors state parties, which isn't really surprising in a state-to-state forum. But so things like an advisory center, sort of equivalent to the advisory center on WTO law, to help states with investment arbitration advocacy, the creation of an investment court, an appellate mechanism, none of which is really going to help claimants or reduce the time and cost of dispute settlement for claimants. And that's something to think about when we're concurrently trying to discuss ways to increase the involvement of smaller claimants in investment arbitration, to say that investment arbitration isn't just for giant multinationals, it's also for, at the very least, medium-sized enterprises, if not small ones, and their ability to access investor-state dispute settlement. And there have been initiatives in treaties more recently, and institutional rules that purport to create more opportunities along those lines for smaller parties, things like expedited or streamlined processors for smaller cases. There's also other mechanisms that can help smaller claimants like junior resource companies, certainly if they have meritorious claims, participate in very expensive investor-state dispute settlement. But I think maybe what I'll do, because I'm conscious of the time, is I'll stop there and just say, so we have to think of this issue both ways. I don't really see how it plays in as much in commercial arbitration in any way that's not common to any commercial dispute. And I'd be interested in hearing other people's views on that. But I know Louise also wanted to say something about how AI tools can help level the playing field, I think, particularly, I don't know if she can explain, but for participants that are less well-resourced participants, maybe whether they are states or they are investors or even in commercial arbitration. So I'll stop there.
Louise, would you like to intervene on the impact of our?
Sure, I was just waiting for permission. Okay.
Yeah.
I think it's a very good segue, this inequality of arms, because I think that AI has a tremendous potential for dealing with that. But on the other hand, of course, you've got to have access to the AI as well. So I think as it develops, we're probably going to see it having a huge effect on the way we practice law in general and arbitration specifically. I was at a conference about 2 weeks ago in which someone said, well, I don't think AI is going to put lawyers out of business right now. It's going to take 5 or 6 years. And everyone looked at the speaker and said, it's 5 or 6 years. It's here. We're living it right now. We are living in an AI world, whether we're aware of it or not. I think that for me, it has tremendous potential, which I'll get to in a minute. But the two things that I'm very concerned about are, well, let me put it this way. When I got off a plane recently, there was a poster at the exit of the ramp, and the poster had a rather blurred X-ray of a suitcase. You know, the one you see when your suitcase goes through the screen, the security screen, and the caption was, "How can we regulate it if we don't know what's inside?" And that's the problem with AI, because there are so few people who actually understand what AI is and how it works, that it is difficult. I think the good news is that AI is probably going to be not only used to create the systems which are going to help, but also to regulate those systems eventually as well. A question about how to do that is another story. But for me, the two things I worry about are, first, unconscious bias, because whatever goes into AI depends on what it has read recently, what it has read all over the world, and some of that may or may not have reputable sources. And probably connected with that, the ability of AI, at least as it stands now, to suffer from hallucinations. I think probably everyone heard about the case in New York a couple of months ago, where 2 lawyers were sanctioned because they had used AI to create, I think, a pleading or a submission. I'm not sure what it was. In any case, AI had made this wonderful argument, and in support of its argument, it had created 2 non-existent cases and used them as citation and cited them. And the thing is that kind of thing would never be caught unless the judge or the other side was doing a very serious work on fact-checking. So I think that the whole fact-checking exercise that goes on when counsel's preparing pleadings, and perhaps even when tribunals are looking at what they are seeing, is going to become extremely important because if we don't know what's in it, how can we evaluate it? So there is, I just by chance this morning happened on an article by his name is Anish Raman, I think. He's the vice president of LinkedIn, and he was saying that he's very optimistic about AI in general because it's going to help us work better. It's going to take away a lot of the grunt work that isn't particularly interested and leave lawyers. Well, he doesn't talk about lawyers, but leaves people generally more time for doing strategic work, and also that the other thing that he's very keen on is the fact that everybody's in this together, and so there's a certain. There's no one conference, but there might be 1 billion people online all talking about AI and various aspects of it at the same time. So if you can get past the noise, I think there's a lot of information there that's available to people.
But how does this tie back to resolving inequality of arms?
Well, what I'm saying is if a quote under-resourced party has the access to AI, it will have the same information available to it as the party that has a phalanx of 30 lawyers doing the research for them. I was reading another study recently where it was on electronic discovery, and when you have a room full of documents and you've got 15 young lawyers going through the documents trying to figure out what's relevant and what's not, apparently the study that he reported on was that the phalanx of humans was about 35% accurate in finding out the relevant information, whereas the AI was about 95% relevant and in a fraction of the time. So what it does, I think, is, if you've got a law firm with 15 people on one case doing your discovery or doing your research, and you can press a button for AI and get the same thing done, it does help with the inequality of arms.
Thank you, Louise. I am afraid we have to end the discussion because I see Una has reappeared and recalls us that the time is ticking. I can say that the students are already using AI in their papers, and that we find the forged sources and footnotes, and that's how we detect them. And it started. We deal with that now in law schools. We have some time left for our rapporteur, Andrea, who has taken a lot of notes while you were speaking. I saw her working very hard, and I would like to pass the floor to you, Andrea, to have your synthesis and summary, and also your grain of salt on all our discussions. So thank you. I pass the floor to you. Thank you, Andrea.
Well, thank you, Charles. I'm very aware of the time, and I will try to be very brief. As everyone was speaking, I tried to take some notes about themes that I thought emerged from the various discussions. One of them seemed to me the idea of trust. Generally speaking, it seems our speakers have trust in the idea of arbitration generally. And I think that is, in some ways traceable, or maybe one of the things that can be traced to early investment treaty arbitration days is that commercial arbitrators were perhaps, and commercial arbitration specialists were tapped to do investment treaty cases and were comfortable doing investment treaty cases because they had trust in arbitration as an institution, and that maybe some of the uncertainty or concerns that some were posed by public lawyers had to do with their lack of, let's say, innate trust in arbitration. We have seen, I think, most of us in our practices or in our study have seen that one of the features of arbitration that we know and love is that the people involved have comfort with each other. They tend to have trust in each other. And that is to some degree challenged now with increasing diversity. It seems to me a trade-off worth having, but nonetheless, it's the case if you don't know your arbitrator and don't have that comfort and familiarity and kind of innate trust. I think Janet mentioned this, that it can be very hard to convince a client that this is a good risk to take. I think that is still a tension, even if it is becoming a little bit easier to have greater diversity. I think Louisa's point about the artificial intelligence is also going to challenge that trust. How can we have trust in counsel if they're forging footnotes? How can we ensure that the intelligence is trustworthy when we're using it? How can we ensure that those using it are doing so in an intelligent and trustworthy way? I think a flip side, a second theme I saw emerging was accountability. Really accountability for, from arbitrators for what they do, from governments for having, selected arbitration, for having permitted investment treaty arbitration, for counsel, I suppose for experts. We haven't talked much about experts, but I think you see accountability in the process itself. We talked about, making it accessible. Matthew was talking about making it accessible to all. I remember Thomas, talking about the Chevrolet model, since we talked, he said, everybody, investment treaty arbitration is a Cadillac. Like, we really need a Chevy model to continue with the General Motors theme that we started with. And, one of the difficulties there is, of course, that if some people are having a Cadillac, then nobody really wants a Chevy. They want a Cadillac too. And so it's hard to sell them on a Chevy, but maybe with the Chevy Volt, that is changing. Sorry. But I think there's greater accountability for choosing arbitrators. I think there's greater accountability for arbitrators themselves with increasing disclosure. And with increasing transparency, there's greater accountability for what governments do, for what counsel do, for what arbitrators do. One of the things that didn't come out as much when we spoke about transparency was the need, or sometimes, if you're really going to evaluate a decision, you need to know what arguments the parties made. It's hard to evaluate a decision in fairly, completely in the abstract. You can say, why did they decide this? Why didn't they look at this? Well, if none of the parties argued it, that might be a reason. And my third theme, and then I just have is, I think, the increasing complexity of and appreciation of complexity. With the advent of Twitter and little phones and little screens, there's as Mark Cantor says, there's a very strong tendency to oversimplify and exaggerate. That's the way you get clicks. That's the way you get somebody to read what's here. And there's a distressing tendency of people to read only what's here, not to keep delving in. But I think we did see in the UNSA trial process, somewhat painful and 5 years long though it was, in increasing kind of a commencement with rhetoric with, oh, this is low-hanging fruit. Everybody agrees we need a code of conduct. How hard can this be? We'll kind of get this done and dusted quickly, and we'll have a victory to celebrate. And then it turned out to be much more complex because of all of these cross-cutting and interrelated issues of diversity, of who you would likely have in and who you would have out. So I think that is a good thing. And I'll just close by harking back to something that Charlie Baduel said at the beginning. He talked about whether investment treaty arbitration was either contaminating commercial arbitration or enriching it, or possibly both. As a lawyer, of course, I think the answer is both, or it depends on what you're talking about. And I'm sure that from the point of view of some commercial arbitrators, they think contamination is all too evident. But I think I would say, putting on my academic hat, is that it is I think some of the complaints about the concerns about investment arbitration bleeding over into commercial arbitration are fair enough, and perhaps I think some are relevant, some are not relevant. But I think more having to discuss, and that having to consider and reconsider questions like, is there a problem with repeat appointments in commercial arbitration? No, they're not as visible, but is it really the case that you want a major insurance company to appoint the same arbitrator for 10 years in a row in enormous numbers of cases? Is that a problem? That might be a problem. And even if it had flown under the radar. So I think we should embrace I think we all have here. I know everybody certainly on the panel, we've embraced the intellectual life involving self-checking, self-criticism, self-questioning. So I think for the kind of the crossover and enrichissement ou contamination point, we should be thinking, does this really implicate commercial arbitration? Not having a knee-jerk reaction, oh, clearly not, but saying, oh, does it? Okay. On reflection, maybe it does not, but here's another point. On reflection, does it? Can we learn from this? How can we make our arbitration process better? How can we enhance trust and accountability in order to preserve arbitration for the future and for the benefit of the parties who seem still to want it? So thank you.
Thank you very much, Andrea. Una, if I see that, can we maybe ask our panelists to each, maybe if they have a final word, if you want to respond to Andrea's comments, or the floor is yours before we conclude.
Okay, I don't see anyone wanting to comment. Charles-Emmanuel,
yeah, thank you, Andrea. Those were very fascinating comments, and thank you for having both reflected on the Oldsmobile metaphor and on my few words in French. So Barry, maybe, or Una.
Well, I mean, I was going to comment, but I'll comment very briefly, which is, I think Andrea's last point, and without the powerful words of contaminating or enhancing, but I think they're, in terms of the public, the users, and you see it particularly in the US, and particularly because of not commercial arbitration, consumer arbitration. You see it in Canada, you see it in the decisions of the Supreme Court of Canada, often arising in commercial cases or class action cases. The public and the system doesn't draw the fine lines between consumer and commercial, between investor state and commercial, and you get things like the New York Times editorial a few years ago, lumping all of it together and pulling out the worst of it. So I think it's an astute and important observation. I think this topic is one that we may not be as at the forefront in talking about it, but certainly it isn't being talked about enough. And I, for one, am glad that we chose this topic. Una?
Okay, thank you very much, Barry, and thank you to all the panelists for amazing presentations. And I'm actually wondering, would you like to come back in a year or so, and we'll do another automobile themed session on the self-driving arbitration, since AI is going to be so helpful. Anyway, it's been very interesting, and I'm sure all the participants join me in thanking Barry and Charles-Emmanuel for moderating this panel, and for all our wonderful panelists and the amazing rapporteur, Andrea, at the end, for this remarkably informative and lively panel on the linkages and intersections between international, commercial, and commercial arbitration. So before signing off, I'd like to remind everyone that on December the 11th at 5 p.m., we will host a virtual keynote address by Stephen Toop on the theme of a rule of law for our age of anxiety, une règle de droit pour notre ère d'anxiété. Stephen will be arguing that a renewed faith in the rule of law can address troubling developments in these anxious times. So it sounds like therapy for all of us. More information about this important conversation and registration details can be found on the ILA Canada's website, LinkedIn, Facebook, and X Twitter, social media accounts. De même, si vous souhaitez en savoir plus sur l'ADI Canada et la possibilité de devenir membre, consultez nos médias sociaux ou contactez-moi directement. So thank you again to all the panelists, and thank you to all the attendees for attending this event, and I wish you all a very good evening. Merci beaucoup d'avoir assisté à notre événement, et bonne soirée à tous et toutes. Thank you. Bye-bye.
Bye, everyone. Nice to see you
Bye,
all.
everyone. Thank you.
Take care,
Great
everyone.
job.
Goodbye, everyone.
Great job.